interpretive function. And this, combined with the judicial restraint that's inherent in the principle of subsidiarity of international control of national action, explains the softer touch, if you like, of the Strasbourg judgments and the lengthier, less formally worded judgments that come out of Strasbourg. Jean-Paul Costa, the current president of the Strasbourg court, said that national judges are more likely to follow the Strasbourg jurisprudence if it is, and this is a quote, accessible, rational, understandable, in brief, credible. Well, the Luxembourg court is subject to no such constraint for its judgments to be followed at national level. And this is why I think the Strasbourg court is also more transparent in its reasoning, especially when it's departing from or varying previous case law. It says when it's doing this, and it says why it is doing it, whereas the Luxembourg court frequently doesn't. Also, the separate opinions that are attached to Strasbourg judgments, in a sense, open the curtain on the confidentiality of the deliberations. The separate opinions explain very often why a particular interpretive door was open and another door was closed. So they illuminate the judgment or the jurisprudential meaning of judgments. Now, this doesn't necessarily mean that national judges, when they have to apply European law in their court, in their cases, that they prefer the friendlier, less formal Strasbourg judgments. At the beginning of this year, there was a meeting between British judges and judges on the Luxembourg court. And there, the British judges said that although they do not necessarily personally like the peremptory style of the Luxembourg court's judgments, they find them easier to work with. They are told, do this, do that, don't do the other. They know where they are. The fact that European Union law has primacy over national law, and the fact that the EU treaties give a monopoly of interpretation to the European Court of Justice, means that it's much easier for national judges to accept the categorical dirigist judgments that come from Luxembourg. Whereas they find the Strasbourg judgments more diffuse. They very often don't know how binding the judgment is, whether it was restricted to that particular case in that particular country. They don't very often know exactly what they're expected to do under this case law in relation to the case before them. So I therefore suspect that the difference in style is not only because of a more formal judicial culture existing in Luxembourg, which is definitely the case, but it's mainly because of the different functions that the two courts serve within their respective legal systems, and therefore the different functions that the judgments serve. We're coming to the final theme, and that is the impact of the accession of the EU to the Human Rights Convention on the institutional relationship between the two European courts. One of the innovatory changes brought in by the Lisbon Treaty in December 2009 was that not only was the incapacity of the Union to accede to the European Convention removed, but accession was made obligatory. The Union is required now to accede to the European Convention on Human Rights. Negotiations are well underway between the European Commission, representing the EU, and the Council of Europe as to the terms of an accession agreement between the EU and the Council of Europe. Now, one does not need to be a soothsayer to realize that the EU becoming a party to this convention and being liable for compliance with the convention in the same way, more or less, as states, is liable to have repercussions on the relationship between the two courts as far as human rights issues are concerned. And there is a fear, indeed, in some quarters in Luxembourg, that not only will accession bring about unification of case law at European level on human rights issues between the two courts, but may involve some danger of encroachment of the Strasbourg Court on the monopoly of interpretation that the Luxembourg Court has of the EU treaties. Well, as matters stand, no application can be lodged in Strasbourg directly against the European Union as regards the action of one of the EU institutions, for example, the Commission. And this is because the EU is not a contracting party to the Convention. No, the only contracting parties are states, the 47 member states of the Council of Europe. It is the European Court of Justice which alone has competence to examine legally the actions of the institutions to see whether they comply with human rights standards. And in particular now, the EU Charter of Fundamental Rights, which was given the status of primary treaty law under the Lisbon Treaty. It is possible, however, for a citizen to challenge indirectly the actions of an EU institution. And the citizen can do this by bringing a case against an EU member state whose authorities have adopted a measure implementing an EU text or decision. Now that can involve a situation where the member state has a choice how it carries out its EU obligation. That was settled in a French case called Cantoni, which concerned the sale of pharmaceutical products outside pharmacies. The director of a hypermarket in France had been prosecuted criminally for selling pharmaceutical products when there was no pharmacy in the hypermarket. And he pleaded that the French law, which implemented a directive from Brussels, he argued that the French law was too vague to constitute a democratic law. But the Strasbourg Court, although finding no violation, although finding the law was perfectly democratic, was not too vague, it nevertheless said that it would examine the case in the way that it would any French law for a criticism of lack of vagueness, and the fact that the law had its origin, its source, in an EU directive did not influence in any way the scrutiny that the court would carry out. But the second hypothesis is where the member state has no choice whatsoever as to how to implement the EU obligation. It can only do it in one way. And in these cases, the Strasbourg Court operates a much lesser scrutiny, a far lighter, less strict scrutiny. And this was established in a case called Bosphorus. Bosphorus was a Turkish charter company, tourist company, which had chartered an aircraft from Yugoslav Airlines. And this aircraft was seized by the Irish authorities in Dublin in implementation of the United Nations Security Council decision telling states not to do any business with Yugoslavia. And the EU had implemented that UN Security Council resolution in the form of a regulation which gave the states no choice. They had to seize any goods when the company concerned had been doing business with Yugoslavia. Well, in its judgment, the court said that the Strasbourg Court said that the EU was to be acknowledged as an international system protecting human rights in a manner equivalent to the European Convention on Human Rights, and that therefore there was a presumption that when a contracting state had not violated the requirements of the Convention, in the particular case it was the right of property, whether the seizure of the property had been in compliance with the Convention, that the presumption, no violation of the requirements of the right of property, when the state in question did nothing more than perform legal obligations flowing from its membership of the EU. Now, this presumption, the court said, could be rebutted, but only if, in the particular circumstances, the protection of the Convention right had been shown to be manifestly deficient. So you can see the bar for violation is set quite high. There must be a manifest deficiency before the Strasbourg court will look into the matter. So if you like, a kind of veil over examining any obligation that emanates from Brussels for the member states. Well, what will happen after accession of the EU to the European Convention? In other words, when citizens become able to lodge an application directly against the EU and its institutions, what will be the fate of this veil? Will it be lifted? Will there be no protective presumption, so that the EU actions will be examined in exactly the same way as national actions? Well, there are two schools of thought. The vast majority of academic writers say that once the procedural impossibility of attacking directly the EU is removed, then the over-sophisticated reasoning in Bosphorus of trying to pin some indirect responsibility on member states because of what they have done, all that reasoning will lose its raison d'etre. And that the aim of the accession of the EU is to end the fact that the EU is in a kind of closed system at the moment, enjoying a semi-immunity from examination of human rights compliance of the BIDS Act in comparison with all other public authorities operating within the EU. And they say also there's no justification for maintaining what at the moment is a double standard. The state actions are examined much more closely. The EU actions at the moment have a privileged position. It's far less demanding, the scrutiny of their acts that is carried out by the Strasbourg Court. And finally, the argument is that this would send a wrong political message to the public. That the whole point of the EU acceding is to show that the EU is just as open to democratic scrutiny by citizens as national actions. However, there is another minority view, it's true, which says that although the Bosphorus case was concerned with national implementation, national action of an EU text, nevertheless, the policy of judicial restraint that it states has much wider justification, and that justification is to ensure a harmonious coexistence between international cooperation between states on the one hand in international organizations, and on the other hand international protection of human rights. And that rationale will continue even after accession of the EU to the Convention. The EU is not a state, it's not even a federation of states. It is an international organization which has specific powers, much more limited than the powers of a state. For these writers then, the minority, the Bosphorus judgment states a reasonable balance between the European Court of Human Rights in Strasbourg as the ultimate human rights court in Europe, and also the existence of another supranational system of human rights protection, that is to say, the one operating within the EU. Well, my own sympathies, as someone who's known both courts from the inside, is in fact rather in favour of the less intrusive approach, the minority opinion, that there should be a kind of rebuttable presumption of convention compatibility, thereby allowing the two courts to work in cooperation and not in competition. Now, it would not be at all appropriate to include in the accession agreement any clause on this particular issue, but it could be achieved through jurisprudential development of the doctrine of the margin of appreciation in cases where the EU is the respondent party. Now, this doctrine of the margin of appreciation involves the Strasbourg Court showing deference to democratic national authorities when they have taken a decision, or as if they have stayed within the range of choices that are available to democratic countries, then the Strasbourg Court won't interfere, even if the judges personally might have decided another way had they been in the position of the national authority concerned. Well, the justification for this approach of a margin of appreciation is the idea that the subsidiarity of convention control in Strasbourg by the court is not the same for the EU as it would be for the contracting states, given the supranational character of the acts of the EU institutions. After accession, it would be relatively easy for the Strasbourg Court to recognize a wider margin of appreciation being enjoyed by EU institutions in a particular area than would be enjoyed by the national authorities if they'd been acting on their own. And this is because an EU legal act already represents a product of harmonizing cooperation between 27 national positions. And human rights compliance will usually have been verified by the other European court, that's to say, the Luxembourg court. So there is, in a sense, less need for intense, detailed scrutiny on the European level. But this is a matter of judicial policy, which is entirely in the hands of the Strasbourg judges. So there is no forecast that one can give, one way or the other, as to whether the Strasbourg Court will maintain its judicial cooperation with the Luxembourg Court by recognizing a wider margin of appreciation than would be present for the national authorities. So we shall just have to wait and see how deeply the Strasbourg Court will dig into EU law and into the prerogatives of the Luxembourg Court. However, the two European courts, have already agreed on the desirability of a procedural bridge being built between the two courts, and that bridge being included in the accession agreement. The two presidents, that's Jean-Paul Costa from Strasbourg and Vassilios Skouris from Luxembourg, issued a joint statement in January of this year where they call for the institution of a mechanism that they call prior involvement. And this would mean that wherever the Strasbourg Court has to examine a case where the EU is a defendant, the Luxembourg Court should have been given a prior opportunity to examine the complaint under EU law beforehand. Now, although it's rather rare, there are situations in which it's conceivable that the Strasbourg Court could be called on to examine a case raising an issue of compliance with EU law without the Luxembourg court having looked at the case. For example, there may be cases before national courts where there has been no reference to Luxembourg for a preliminary ruling, simply an application direct to Strasbourg. Consequently, so the joint statement reads, as part of the accession package, and this is a quote, a procedure should be put in place which would ensure that the Luxembourg court may carry out an internal review before the Strasbourg carries out external review. And what this would involve is that the proceedings in Strasbourg, after the application against the EU had been lodged, would be suspended and the case sent to Luxembourg, while the Luxembourg would examine the matter under an accelerated procedure. This would neutralize fears of the Strasbourg court being drawn into interpreting EU law in any way, since the Strasbourg court would always, in all cases, have before it an authoritative ruling on the EU aspect from the EU court. That's to say the Luxembourg court, and in particular the Luxembourg court would presumably examine the case under the Charter of Fundamental Rights. Now there would appear to be a consensus between the negotiators, and there is in the draft accession agreement, which was published recently, a clause providing for such prior involvement. But I think this demonstrates that the regular dialogue, the regular meetings that take place between the Luxembourg court and the Strasbourg court have moved beyond mere case law discussions on matters of general interest into practical cooperation designed to ensure that human rights protection in Europe is effective and coherent. So although the question of the institutional balance between the two courts, who has the power, as it were, is a matter of speculation, given the entente cordiale that the joint declaration of the two presidents represents, I think the signs of harmonious judicial dialogue and even practical cooperation between the courts are encouraging. That brings me to the end of the few remarks that I had to make. You will notice that I haven't said anything in this discussion of the relationship between the two courts in human rights matters. I haven't said anything about how one might identify what human rights are. And on that I can quote to you a cartoon that I saw in the British newspaper The Times on the day that the European Convention on Human Rights was incorporated into British law in 1998, meaning that British judges would be for the first time called on to start talking about human rights in the cases before them. And in this cartoon there was an advocate talking to his trainee advocate. And the lawyer, the advocate, is saying, if you have the law on your side, you should always argue the law and concentrate on the law. And in the next box it said, if, however, you don't have the law on your side, then you should concentrate on the facts. Argue the facts, the specificity of the facts. And to this the trainee says, but what do I do if I don't have either the law or the facts on my side? What do I do then? And the advocate replies, well, in that case you tell the judge it's a human rights issue. So, on that note, I will say thank you very much.
Thanks again, Mr. Mahoney, for this excellent presentation. It is a fascinating topic. I regret we cannot open the floor for the questions. There will be certainly many, for the stakes are high. Perhaps the stakes are the highest yet. The question that is being raised is actually, who is the ultimate arbiter of constitutionality in Europe? Is it still the national courts, the national constitutional courts, maybe the European Court of Justice, or are we drifting towards the European monism that will be somehow hidden in and concentrated in the European Court of Human Rights? If the latter, then we will need to rewrite our commentary of the Constitution. Tako, hvala lepa, zdaj vas pa res vabim na kavico, a coffee break for 15 minutes.